Mr. Kamoto also said that this court can sit on any day, at any time, continuously. Section 10, subsection 7 of the High Court Organization and Administration Act 2015 does not support his argument. That section provides, and I quote, the Chief Justice may, where necessary for the expedient and proper exercise of judicial authority, authorize the sitting of the court on any day or at any time. The sitting of this court on any day at any time requires express authority of the Chief Justice under Section 10, subsection 7 of the High Court Organization and Administration Act. My learned colleague, Mr. Nyamodi, made an important point, and I think I support that point. The Constitution says what it says, but it means what the court says. Very crucial point. The Constitution at Article 165, Clause 4, says who can constitute this bench. That is the Chief Justice. Can the DCJ also do it? Is that an administrative or a constitutional mandate? The jurisprudence by this court, as we have alluded to, is 3 cases. The Omtata case, the Kemri case, and the Leila Conchela case. The Omtata case and the Kemri case present that as a constitutional mandate of the Chief Justice. The Leila Conchela case at the High Court level presents it as an administrative function, but we now know that the Court of Appeal has found that to be an arguable point on appeal and has given a stay order on the strength of that arguability. The weight of that jurisprudence militates against finding that this is an administrative decision, as has been urged by my colleagues from the other side. Since I have only 5 minutes, an issue arose here, my lord, my lady. We tried to object, but we were told we will have a right of reply. Professor Jenda presented a piece of paper from his hand, claiming it's a memo from the Chief Justice. We sought clarification on where that paper has come from. First, his argument was it's in the portal. We sought to know in which case file in the portal that paper has come from and why it has no timestamp that is symptomatic of all documents that are lodged in the portal, and there was no clarity on that. He then said, Mr. Nyamodi will comment on it. Mr. Nyamodi stood, began, and concluded his submissions without commenting on it. He also told us it is in the file. Papers like this will find themselves in the file through affidavits. This is evidentiary material. Again, we were not told which affidavit or which deponent filed on which day. We would therefore urge you that as you consider this matter, you take into account that we have not had a fair opportunity to treat this piece of evidence in its proper context because of the, with respect, woolly nature of the manner in which it has been presented before this court. I urge, my lords, that in view of the matters raised before you, this matter ought to finally clear the position of this court on the jurisprudence of Article 165, Clause 4 of the Constitution. You give it considered thought, and that you return this file back to the appropriate authority, the Chief Justice, to do that which is just and right, as per Article 165, Clause 4. In matters as fundamental as this, in a matter where we all agree that this is a defining moment for our country, we cannot afford to be casual about it. We cannot afford to be expedient about it. It's in matters where a question of principle arises, and of all the 3 organs of government, only one organ stands out for standing on principle: the judicial arm of government. All other arms of government stand on politics and policy, but principle is reserved for the judicial arm of government. We urge you to admit that principle and find that the applicants and their supporters before you have made out a case for you to down your tools in this matter on the strength of the manner in which you are constituted. I rest my case.
To respond to the application, as well as any other party which will want to respond to the application?
We are aware that there could be parties who, for the good reasons given, may not have filed anything. But we also appraise ourselves of the fact that the issue before the court is an issue of law. Therefore, we'll give you time to make submissions on the issue.
May I please? The client, I and my colleagues represent the deputy president, is the subject of the removal of the subject of his pleas to this honorable court. For him not to be. The application for the constitutional bench is made in E015 by my friends given away, so that effectively the subject matter of removal is being given only 5 minutes. I plead with you, give us 10 minutes.
How long do you need?
10 minutes. I would have said
you have 10 minutes. You have 10 minutes.
Yes, yes, Dr. Kamina. Yes.
Well, I received the instructions yesterday.
Dr. Kamina, we are not audible.
Oh, I'm sorry, I speak loud.
Yes, speak.
I received the instructions yesterday from the Georgia Syria that I come and make an application that Georgia Syria would like to be enjoined. We all know Georgia Syria. We can't pretend to be and we know the role Georgia Syria has played in advancing the students' constitutionality and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen quite a number of things which I may not be able to say if I'm representing the court.
That is okay. You have done that.
Thank you very much. May I then comment on one small thing?
Yes, sir.
My lord, the country is in a crisis. It's a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so, with tremendous respect, this is not a matter where it should be allocated some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 50 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mwite, will only have 10 minutes, will have no 5 minutes.
Mr. Mwite asked for 10 minutes and we allowed him to have 10 minutes.
He said so because he was under coercion.
What?